Good evening and welcome. I'm Charlie Hullman. I'm your Senior Executive Director of Special Education here in Wayne-Westland, and I am very happy to announce that tonight Wayne-Westland Community Schools, in a partnership with the ARC of Western Wayne County, is very pleased to welcome you to tonight's presentation on alternatives to guardianship and self-determination. Before I introduce our speaker this evening, I'd also like to introduce Cheryl Polite. Cheryl's online with us as well. Cheryl's the director of the ARC of Western Wayne County, located right down Wayne Road here. And Cheryl is responsible for arranging our speaker this evening. Cheryl, give us a wave.
Hi, guys.
Our speaker this evening is attorney Patti Dudek. She is the principal of Dudek and Associates. Her practice concentrates on elder law, Medicaid, estate planning, estates and trusts, administration, probate, and administrative law disability advocacy. Her practice includes advising and preparing estate planning documents, including special needs trusts, representation in Medicaid hearings, and to secure appropriate services. Ms. Dudek has received many awards and accolades for her work. Multiple times she has been awarded as a top lawyer, not only in the state, but in the nation. And so we are very pleased to welcome her here. Along the way, I will be your moderator. If you do have a question, please enter it in the chat. I will unmute, ask Patti your question, and then if you want follow-ups and things like that, please just continue to put them in the chat, and I'll continue to moderate that for us all. So without further ado, I welcome Patti to Wayne-Westland Community Schools and thank her for her work to help us all gain a better understanding. I'll turn it over to you, Patti.
Hi, everyone. I'm so glad we're able to. Can you not hear me? Somebody's pointing to her ear. Okay, hold on. Can you hear me now?
Patti, you're coming in loud and clear here.
Okay. Okay, thank you. If you have other issues, folks, just let us know. There's also captioning, I believe, on Zooms if anybody needs it. So our topics tonight are alternatives to guardianship, and there are lots of alternatives to guardianship, and the important thing to know about those is that there is no one answer that's perfect for everybody. Everybody's situation and factual circumstances will be different, and so therefore the combinations of protective arrangements you can use to make sure the person will not hopefully need a guardian in the future are interlocked but separate, and I'll explain that as I talk about it. So right now I'm primarily going to focus on the law in Michigan related to what a guardianship is for a person with a developmental disability. That is a different law than there is for everyone else in the state of Michigan who might need a guardian. In some ways, it's a good thing that we have this separate law. In other ways, it's kind of a bad thing. It's bad because we have this separate law with additional protections built in because people were overusing the guardianship system in our state to just pretty much control people with disabilities. And what we saw was folks would be going into the probate court as they were potentially being placed out of maybe an institution, and the hearings were less than a minute long. And because of that, it was really felt that this system was not really quote unquote objective or reviewing everything they needed to do to make sure that these folks with disabilities were receiving what they need from the potential guardian. And so the ARC, to its credit, and that they believe nationally they have been a leader in this, not only advocated to make it harder to get a guardianship in Michigan, but made it easier for it to go away, and made sure in every situation where there is an issue related to if there is another alternative to a guardian that you could use, that is available easily accessed by families who might need it, and have really been at the forefront of this issue nationally. Okay, somebody keeps shaking her head. Is that Tabitha? Can you not hear me? Or maybe she's not doing it to me. Okay, so I'm going to keep talking. So let me just preface this, that the alternatives to Guardian can be, there's not just one that might work perfectly, there are several. So the most important one for all of us today on this Zoom, and that includes a person with a developmental disability and anyone who may need a guardianship in Michigan. The best and most effective and efficient way to avoid the need to have the court involved in your life for the rest of your life is to put in writing what you want while you're capable of doing that. Okay. And when I say capable or competent is another word they would often use to do that, that's the standard for you and I. So if I draft a power of attorney, I have to be considered competent to give that power to someone else. Okay. And I can be as specific or detailed or creative as I want in this document. And there are lots and lots of versions of them. Some people make fun of us that we get paid by the word, and it's not true, even though my power of attorney is probably longer than 90% of the attorneys out there. But the reason why I did it is that way was because I tried to put every specific power I could think of in there, including powers that are already statutorily available to these folks through the law. But I want it in the document because not everybody who gets asked to act as somebody's agent under a power of attorney knows what the law is. So if you just reference the law, I don't think it's clear to a lay person. So I actually cut and paste and improve upon the language in my powers of attorney from the law. I think they're wonderful. So a power of attorney works for all of us, but it can also work for people with developmental disabilities because they can sign one that is signed with an X or signed however they sign. It could be one that's modified based on what their priorities, or it could be a traditional one. Because the law in the state of Michigan, and really I think every state, is that if there is not a prior determination of incapacity, then the person is considered competent to sign their documents. And if you have evidence of questionable capacity, you can ask for people to follow up, but you don't have to. You are not obligated. The law is you must presume that they're competent. Okay. Now, if a person has a developmental disability, they can be competent or incompetent. But if they have a developmental disability, they have to, if they need a guardian, go under the DD statute, which is Chapter 7 of the Michigan Mental Health Code, is the process for getting a guardian appointed for a person with a developmental disability. But they don't have to, but that's the preferred method. So if the person's developmentally disabled, they could still also sign a power of attorney, especially if they haven't had any determination of incapacity, and they could put in writing who their preferences are for successors to act and what kind of powers they may or may not have. What that will do is allow that individual, and or with the assistance of their circle of support, to have more self-determination related to who may be appointed to take the lead in making very personal decisions for this person in the future. And so it would be evidence of what the judge would have to look at. Okay. The DD statute, unlike the probate code, which is EPIC, is what I will refer to it. And that's the one that refers to everybody who's not developmentally disabled or a minor. Then EPIC, that is a determination of capacity. It is not a determination of a developmental disability. One of the most common reasons I had heard from my clients when I first started practicing and or working working at the ARC as an advocate, was that they thought a determination that the person met the definition of developmentally disabled by securing a guardian for them would be helpful evidence that could be used, or even a fait accompli that meant they would get services approved from Social Security as a person with a developmental disability. The two definitions are very different, and it does not really help. It doesn't hurt to have it, certainly, but it doesn't, you don't have to have that in order to access the benefits. Also, even in the last 3 years, probably, I heard a probate judge tell one of my clients incorrectly from the bench that if the person got a guardianship of a developmental disability, rather than using a power of attorney, which is the lesser restrictive option, they could get more services from MORC, which is our big agency, one of our big agencies in Oakland County, which is absolutely contrary to facts and law. But, you know, when you're in front of a judge in the States, you can't really get in an argument with them too much, because then you're never going to get what it is that your client wants. And so we didn't duke it out. But I did have the discussion with her later, and hopefully had some impact on that. So what I want you to hear is the big distinction between the determination of a judge deciding who can and cannot make decisions for you, and the decision of a person with a disability being able to have input into who that person is. So under EPIC, there have been a lot of changes recently signed to the guardianship law from EPIC. They're not effective yet. I don't actually even know if the governor signed it yet. And so stay tuned. There will be some changes coming, but under EPIC, they want medical evidence of incapacity. Under the mental health code, that is not the standard. It is not that the person is not capable of providing for themselves or their financial means because they have a disability. It is, do they meet the definition of a person with a developmental disability? And because that's not the only thing, because not everybody with a developmental disability has to have a guardian. So the first step is, are they developmentally disabled? And the second step is, are they in need of protection from abuse, exploitation, or neglect? Those are the three things. Are they at risk and need protection from abuse, exploitation, or neglect? And so that is a secondary finding. Another finding in that law that the judges have to make is that whatever they're going to do is the least restrictive way of making sure this person with a developmental disability is protected from possible exploitation, abuse, or neglect. In the old days, they would just say that. Like, just magically, they would say, poof, you need it, and you're going to get the guardianship. The advocates from the ARC have done such a good job on this topic, and kudos to Don Hoyle, any of you who may have met him in the past. But what he really fought for was, do they look to see if these alternatives are in place? And if the alternatives are in place and being used appropriately, then the person doesn't meet the standard of needing a guardian because they're at risk of exploitation, abuse, or neglect. So let me give you an example what that means in English. So if Cheryl Polite was my sister with a disability, and she signed a power of attorney appointing me as her agent, and I have been acting as her agent, and then the agency doesn't like what I'm trying to advocate for, and so they choose to file for having a guardian appointed, because that will happen frequently, and frequently that's because the person who gets appointed as the guardian gets paid through the agency, and so they're much more compliant and less as outspoken of an advocate as many family members may be. And that could be the opposite too. It's all over the place. But anyway, I digress. So, but what they've done is now they have to look in EPIC. There's a requirement that the judge cannot appoint someone to act as a guardian who is not in this preferential list. And the preferential list is the person that the proposed protective proceeding is for. So the person who may need the guardian. So my situation, my example was Cheryl. If she already had a power of attorney, the petition's supposed to be dismissed unless the power of attorney has refused or predeceased and is doing something in conflict to what would be in the best interest of that person. So they've now got these systems in place where that if someone tries to petition for a guardian, the guardian ad litem or the clerk may be looking to see if other less restrictive options are in place. And one of the most frequently and best options for that is a power of attorney. Now, besides a power of attorney, there are other options that can be used to eliminate the need for the guardianship, because many people with developmental disabilities need some help with financial management, but may not need day-to-day hands-on, but some. And a lot of folks with developmental disabilities may be receiving Social Security checks, either in the form of SSI or Social Security Disability Income, SSDI. Either way, or as a heir, or as a deceased spouse had died or something like that. There are other ways you could be getting it and be disabled. But one of the options you can use to avoid the need for the guardianship is have the money be handled by what's called a representative payee. Now, I hope all of you have probably heard of a rep payees before, but it really works well because the person with a disability can appoint someone as their rep payee, and it can be done with a form online. It doesn't, you used to have to go in and talk to people. Now they're much easier about getting it. And then what that happens is the rep payee gets the check, or the cash is deposited into the account automatically, and then the rep payee pays everybody. That limits how much money the person with a developmental disability has access to. And in many times they are preyed upon because they have access to cash, and they tend to be very trusting. And so if they have access to cash and there are people around who may want to exploit their trustful nature, they could be at risk. So limiting how much is actually cash has really helped in limiting that kind of exploitation and abuse. And so much so that the states, I think now all use like a prepaid debit card for food stamps. So even your food stamps allocations may come on this little thing that looks like a credit card, and it's not cash. So it's less accessible from someone who may want to exploit the person with the disability. So you could have a person who's just not financially savvy. And so that if you want to avoid the need for a guardian of the estate, which is the same thing as a conservator is for people who are in need of protection with their finances under the EPIC statute, not the DD statute. That is a wonderful alternative, the rep payee process. Was there a question we wanted to pause for?
Yes, there are two questions in the chat right now.
Right.
The first one, and I'll give you a chance to answer it before I ask you the second one, is how can a parent get a medical power of attorney is the question.
Well, I think what they mean by that is that the parent wants to be appointed medical power of attorney for their person with a disability, and not the parent is giving that power to someone. But either way, there are forms that the State Bar of Michigan have online that you can download and use. You could come see a private attorney like me. You could go visit with the folks at the ARC. The ARC have some forms that they have available as well. So there are lots of ways to do it, and there is not one specific format that's better than others. It's just some of us put more information in than others just because we don't want to have to deal with the headache later if we can avoid it. and the same thing applies if you're looking to do one for yourself, that the state bar has one online. I would just say that that one you probably want to look at a little bit more for specific language.
And a follow-up to that one a little bit. And the person wants to ask, for a POA, do I need an attorney to prepare this document, or is it something I can do myself?
What a great question. So if it is a person who capacity or disability is not questionable, sorry about that, I had to turn my light on, then they can do it from the state bar website or the ARC ones. You don't need a lawyer. I'd probably say most of them are probably not signed with lawyers, frankly. If I'm doing an estate plan for a family and including a special needs trust, I usually throw it in. And so you don't have to see a lawyer, but sometimes you want to, just so there's coordination with everything else mom and dad are doing.
Excellent. There's one more question that got added as we were starting to ask some
Sure.
questions. So I'll ask this one, or I'll ask this one, and then there's one more besides that. So one question, just to kind of follow up on this, is how long does it take for a power of attorney to be established under an emergency situation?
Oh, that depends on the emergency. There is a fallacy out there that people can sign powers of attorney up to the moment they die, and they can't. They could sign a will like that, but not necessarily a power of attorney. So it depends what the emergency is. If the emergency is some kind of capacity issue, it may take a while because there may be a fight about capacity. If it's not that issue, 24 hours. You don't have to have a lawyer. You need 2 witnesses and a notary. You can download a form online and do it. So if it's an emergency because you want help with something, because someone's trying to collect on a debt for something, or someone is trying to exploit you, then I would say go to the ARC, and they can usually get it done pretty quickly with help from me and a cadre of other attorneys, I'm sure, to try to avoid the emergency. But depending on the emergency, so are there other questions?
So that, I think that was a clarifying, it was for a brain injury of a 19-year-old, I think is what this person is saying.
Okay, so the 19-year-old just got injured, and can we do it right away so we can get the settlement or whatever? Yeah, that's quick. It shouldn't be hard, as long as the person can sign with assistance or nod or whatever way they communicate. It shouldn't be difficult to get one at all.
Excellent. The last question, and then I'm going to leave you alone for questions for a little while, is about speaking with you directly. And I know we'll cover that at the end, where you'll give some outline of how we can get a hold of you and things like that. So I didn't want that person to think we were forgetting about them, but we'll do your contact information at the end to make sure that folks know how to get a hold of you.
Put a pin on that and we'll come back to it.
I will do that. I will do that. Now I'll leave you alone for a little while.
Okay, so we've been through some of the alternatives already. We talked about a power of attorney. We talked about a representative payee. Okay, so that could handle legal, financial, and general medical decisions. And then a rep payee handles any money or finances that go through Social Security. So then we have issues where a person with a developmental disability, just like anybody else, could have a mental health challenge as well. And there are lots of folks who have more than one diagnosis. I have, sadly, like 7. But a lot of people have ones that maybe they have a developmental disability and depression, or they have a mood disorder, or lots of folks with Down syndrome tend to get Alzheimer's or dementia at significantly younger ages than the rest of the population. So you can have more than one disability connection. And I think that having our separate law kind of confuses people, but I think what's nice about it is that these guardianships have to be renewed every 5 years. Now, I know the families don't really like it, especially if they're running around like chickens with their heads cut off trying to do 8 million IEP meetings or IPOSs, filling out paperwork and being a primary caregiver is exhausting. But you want to try to help them along as much as possible, or to try to make it as easy as possible for them. So the next option that you could potentially use in an emergency. So if the emergency is somebody wants to remove someone from their home, which is a very common one, because of a mental health condition, okay? The only legal entities in the state of Michigan, there are only two who can admit you to a mental health facility against your will. The first is a probate judge, and it's exclusively a probate judge. Can't be a juvenile court judge, or they can make a recommendation. That's the first one. The second one is a person who has been appointed a patient advocate under a patient advocate designation that gives them, that revokes the ability to terminate the document. Now, what the heck does that mean in English? Okay, so for decades, the only patient advocate Michigan had was about being able to end life, turn off medical treatment, say no, do not consent to existing treatment. And that in some ways included food and hydration. And that is because we had a really important case in Michigan called In re Martin. And that in the, I want to say the shenanigans of Dr. Kevorkian kind of gave us some really goofy law in Michigan. And so the law was, as a result of that case, that the courts will always err on the side of life unless there is clear and convincing evidence of what the person wanted when they were competent. Now, remember, a determination that a person's developmentally disabled and needs a guardian under the DD statute is not a finding of incapacity. So they can still execute a patient advocate if they want. They don't have to, but they can. So this document is very easy. You have to be able to understand, I'm sorry, I think the doctors have to certify that you are unable to engage in medical treatment decisions for end of life or for mental health, okay? If it's mental health, you have the flexibility to write into the patient advocate what mental health professional or medical professional you want to make to the determination that you need this advocate to help you. So some folks with mental illnesses have many medical providers. They have a psychologist, they have a social worker, they have a psychiatrist, and they may like the psychiatrist and not the counselor, or vice versa. So they can say in the document who their preferred person is to make the medical determination that they need mental health care or treatment against their will. Not to do it, but to make the medical clinical diagnosis. After that diagnosis is met, then the patient advocate can say that it can't be revoked for a certain time period. And that is because many people with mental illness, prior to this law being written this way, would draft a patient advocate for medical. And when they started to decompose, because many times a person with a mental illness or dual diagnosis starts to be doing really well and they don't like the side effects from the medications, just like me with my asthma medication. I get cocky and think I don't need it anymore, and then I have to go back on it, and it's up and down and ups and down. Well, when you're in a down moment of that and you have a mental health issue, you're at risk of inpatient hospitalization against your will. Even if you don't have a mental health issue, if you're just developmentally disabled and you present unusually, which can happen to people with autism who communicate in non-traditional manners, it could be a lot of things. So this patient advocate stops anyone from being able to admit you against your will, unless it's the medical provider saying yes, they need it, and to your agent doing it, not a probate judge. So it's all done privately, and you can't get mad at the agent and say, oh, I revoke it because you're going to just put me on that medication I don't like. Now it says you can't revoke it for up to 30 days. And that way they can potentially get the person with the disability some medication, and it takes at least 2 weeks, sometimes longer, for a lot of psychotropic medications to get in the person's system enough to be able to change behaviors. Sometimes it makes the behaviors worse and you got to change the medication again. So you have to be really cautious about that. So a really important document for every single person to have, including people with developmental disabilities, is a patient advocate. One about end of life, because a guardian doesn't get that appointment. They never have the power to make the decision about end of life. That remains with family, and or the person with a disability can put that in their patient advocate and say who their preference is. or this mental health document. And so sometimes you get these calls from folks like, it's an emergency, grandpa wants to walk out of the nursing home and we're trying to keep him there. Those kinds of things don't always get fixed right away, because if they're not compliant, frequently they're going to try to rip up the power of attorney. So some of these do have risks, but the point is, by choosing these options, you've still chosen the option that takes the least amount of freedoms that are available to every other US citizen away from the person with a disability. It's the person giving it to somebody, not a third party government in the lieu of protection and providing services that would make sure they were not at risk of exploitation, abuse, or neglect. They just appoint guardians and say magically it's now been resolved. When I can guarantee you, and I know Cheryl can tell you, there are hundreds of guardians who are guardians for thousands of people. And so if you're trying to be an advocate for that many people, your amount of time that you can be effective is limited. And so that's what we mean about this wholesale use of guardianships, and why we've become so creative with these alternatives. So then there's another alternative that we don't always have to use, but I really like it. And a lot of states, including California, don't have it. And that is a protective order. So a protective order can be when you got to go to court because Grady and Susie left Cheryl $100,000 life insurance policy, and left it to Cheryl directly, not understanding that Cheryl was getting SSI and Medicaid, and that could put her at risk of losing her benefits. Okay. So if something like that happens, and it's a one-time only transaction, Michigan will allow us to go to court and get a protective order on behalf of a person who is vulnerable, without a prior protective proceeding. Now, what the heck does that mean in English? So for decades, they used to tell us you can't get a protective order unless a guardian or conservator is the one requesting it. So it didn't help minimize how many people got guardians and conservators appointed. So this, by changing it and making it clear that the law allows for it without a guardian and conservator doing it, made it a lot easier. So for example, in my example, and I'm Cheryl's parent and Cheryl's getting $100,000, I can ask the judge, hey, judge, this is going to screw up her Medicaid. Will you please order this settlement check to go in an ABLE Act account or a special needs trust or go wherever? But I don't want to have to open a guardianship of the estate that I have to renew every 5 years and report all the income and expenses every year. And they will let you do that. And so that is another really nice planning tool that allows for settlements, protective orders. If somebody tried to get a person with a developmental disability to sign a contract for a new phone or a new car, and they thought that because the person didn't have a guardian, they were golden. Well, they weren't, because the person had an agent under a power of attorney, and so they didn't have that power to sign that contract. And I can almost always get them out from underneath something like that. So we have all these great protections, and then we have the fact that our guardianship, if it's a partial guardianship, has to be renewed every 5 years. Now, there is a split of authority. I will tell you that the judges think that unless you can prove that they're not developmentally disabled anymore, the guardianship has to remain in place. I'm sure Cheryl can tell you, as well as I can tell you, of hundreds of cases that that is just not true. After 5 years, if there's nobody willing to act, they often go away and they just end. And then our colleague, Sylvia Clark, went through this with her son, because when he was first turning 18, she had to get the guardianship to be able to communicate with the schools and so forth. But then as he got older and she started to learn more about self-determination and wanted to give Stephen as many supports as possible and allow him to be as self-determined as possible, we let that guardianship lapse, and Stephen signed a power of attorney appointing his parents and then his siblings afterwards as his agents under power of attorney, and he never had to go back for court guardianship, because we allowed it to lapse, to just be suspended. If it's an LIP guardianship, so the other ones under the probate code that would, or EPIC, that would apply to us, if I get a guardian or conservator appointed for me because they've determined I'm no longer, I have no legal capacity, or I can't do it, I can't get out from under it unless I can prove I have regained capacity. And so that is a very tough threshold to prove, where a person with a developmental disability can get out of it if they can prove that there are other alternatives just as adequate as the guardianship to protect them from abuse, exploitation, or neglect. Remember, those are the three things. It's a two-pronged test. One, you are developmentally disabled clinically, but not only that, but that you need this to be protected. If you have a power of attorney with a patient advocate and a rep payee and a trustee of a special needs trust and someone helping you with your ABLE Act account, you have more protection than 90% of the people in the world, and no court intervention, which is really, really nice. Before I move on to talk about what do we do about self-determination, if the individual's desires are in conflict with the guardian's desires, let's see if there are any questions pending. Are there any questions pending?
Well, there is one question in the chat, Patty, but it's a really specific one. So what I'm going to ask is if you have really specific ones where you're talking about one single thing about maybe your child, and is this a sufficient POA or something like that, I'm going to ask that they reach out and contact you directly, and let's make sure that our questions are more general in nature and not specific as to, is this a legal document? If it's general, can I have this notarized at the bank? Certainly we can answer something like that. Or how would we get something notarized? We can answer that. But if it's specific to a case or something like that, let's have that person reach out to you more directly so that you can help them out, or even contact Cheryl Polite and her great team at the ARC to be able to help out with some of those kinds of things. It's about a little almost 20 minutes to 7. And so I'd like to take about the last 10 minutes to answer questions and things like that. So if you've got those, start populating those into our chat. Jenny's been doing an excellent job of sending those my way. And so if you've got some questions, we're going to try to leave that last 10 minutes or so for those. So now is the time to enter those into the chat. So thank you, Patty. I appreciate you continuing.
Of course. So now I'm going to talk a little bit about what self-determination means in terms of services. So the Medicaid statute is a nightmare. And if you ever have insomnia, I encourage you to read it. It will help you fall asleep. And it is not only is it a nightmare and it's crazy federal law, but because it is a program that's run jointly with the states and the districts and the territories, each state and territory or whatever has different sets of rules for their Medicaid. On top of that, Michigan, and I'm not sure if I'm 100% accurate on this, but right now I think they have 10 different Medicaid programs, and they all have different avenues for eligibility and criteria. And so it's very confusing for folks to understand this system. It is one of the most convoluted things in the world. If it makes you feel any better, there are Supreme Court judges who didn't understand it either. So it's not unusual that it's this complicated, except that I think it's done purposefully to disenfranchise people who need Medicaid more than they are already disenfranchised by the fact that they're usually on this program because they're in poverty. I'm very cynical about it, but if you can give me another reason, please tell me. But the reason why I'm bringing this up is because when Cheryl and I started working together, a lot of the folks at the ARC were fighting really hard with their education programs to get what they thought was mainstreaming, or some people wanted full inclusion, or wanted some kind of connection between their loved one with a disability and their school related peers. And that is because this was the first generation going to special ed with special ed who lived at home, quite honestly, or majority of the time lived at home. So these families who, as you know, fought really hard. Michigan had special ed law before the federal IDEA statute was written. Michigan had a Handicapper Civil Rights Act, or it was called Elliott Larson Civil Rights Act, decades before a lot of other states did. So after doing all that advocacy and seeing how wonderfully their loved ones were able to be incorporated into the community, again, I'm going to use Cheryl and I's colleague, Sylvia Clark, as my example, because her son was the same age as I am. And when he was born, they suggested to her that she should take him to an institution and forget she ever had him. You know, that does not happen anymore, ever. And in fact, in Michigan, we don't have any institutions for little kids anymore. Usually it'll be a hospital or a medical home setting instead. So we've come a long way. So once the families who fought so hard for these improvements started to think about when they weren't going to be around, they didn't want to have their child or loved one be at the mercy of the Medicaid system that would then just backfill a slot available in an institution or a group home. Because for decades, I don't know, Cheryl, you to remind me, like 20 years, there was waiting lists. There was nothing we could do when someone's family member died. The response was the person would be plucked out of their family home and taken away from their community connections where they were living a pretty self-determined life because they were born and raised with this community. And we separated them from their community, forced them in an institution or a group home. And the only way they could get back to their home or to their community was after a protracted fight. Well, that doesn't happen anymore, thank goodness, most of the time in Michigan. So what happens now is the system tries to respond. Now, I'm not saying the system's perfect, but they will respond and they will try to maintain that person in the least restrictive setting. And when I say try, even though that language was in the law before, I would tell you, just like there was language in the guardianship laws that said use the least restrictive form of protection, they ignored it because it was easier to treat them all like one. So that's the same kind of thing that happened with people who needed services. So again, thank you to the ARCs and other advocates who have worked with the Department of Health and Human Services and the Administration on Community Living. They have really pushed Medicaid in the direction towards Medicaid waivers and allowing those services not to be tied to brick and mortar. So what that means is in English, again, if we need services, a lot of us think we have to go to a particular program or nursing home or group home to get those services. And we cannot afford to build enough group homes, nursing homes, and institutions for all the people who are going to need support in the future. And that is a bad public policy. To force everybody to take the most restrictive, most expensive, least wanted program and hope less people will come for help is what our policymakers have been doing. But we have, as advocates, have pushed it in the other direction that says the individual gets to decide where they live. And the housing and the services should be separate, so that if they're living in a home where they signed a lease and they have a falling out with the service provider, they don't have to move. Just like anybody else. If I hire someone to clean my house and I think they're stealing from me and I don't agree with it, I can change the locks and fire them. Why would we not want to empower people with disabilities to have their own self-determination to do that? Because all too often, the first set of folks who may abuse them could be direct care staff or people interacting with the other people they're living with. And so we want to protect them from having to be removed. Now, our system has not evolved as quickly as we liked, because especially for seniors, you know, everybody thinks of assisted living or a nursing home. They don't think about bringing in some services in their home for a while, although long-term care policies are. Anyway, the point I'm trying to make is self-determination is really push Medicaid to get better about this stuff. And one of the things that's really important is if the ward, the person who needing protection, doesn't agree with the guardian, there's got to be some checks and balances about how that's addressed so that the guardian isn't just restricting that person's freedoms to make their life easier, which does happen. I hear parents, I don't like this boyfriend, or she's going to be abused or whatever. That's not the way to handle it. There are other ways to handle it. And the Medicaid system, believe it or not, will pay for support services and counseling to the family from the supports coordinator to try to make that happen. So that's how we work out those conflicts when a guardian may want to do one thing and the person may not want to do it, or that kind of thing. So I think I got to where we still have time for questions.
And of course, I have trouble with unmuting, but
everybody does.
yeah, I don't know when I'll ever get good at this, but I guess today was not that day. So there haven't been any other questions that have joined into the group, so I'm giving it just a minute to do that. I did want everybody to let everybody know that this meeting has been recorded and that we are going to post this on the special education portion of the Wayne-Westland Community Schools website. So if you wanted to go back and take a look at and review some of the things that were discussed today, or maybe share it with a friend or those kinds of things, that would be available to you. Cheryl, is there a possibility we might be able to link this to the ARC as well?
Oh, absolutely, Charlie.
I was just going to say, don't you guys also have draft forms, powers of attorney, and letters of intent you could link that would be helpful to people?
Yes, we absolutely do. Tequila Smith is our systems navigator and should be more than happy to assist family members who are in need of those documents. And Patty, I'd just like to say hats off to you as it relates to self-determination. You know, Patty was very instrumental in drafting the tripartite agreement for the state of Michigan when we first entered into self-determination arrangements. So she's been instrumental in this process all along. So thanks, Patty.
Well, thank you for making me do it.
So I'm taking one more look at the chat. I'm not seeing anything else there. So I do you have some final words of wisdom for us, please, Patty?
Yeah, my final word of wisdom is please don't take it personally if you can't get a hold of me personally. I am recovering from a compression fracture in my back, so I'm only able to do a certain amount of work a day before my head gets a little loopy from the pain. You can email me. My email's on pretty much everything, and I will get to you. And if I don't, call and remind us, leave a voicemail and I'll get to it. I'm just behind right now, and please don't take it personally, or call Cheryl, because Cheryl will hunt me down and she will admit it. She's made me come in on Labor Day to the hospital and all kinds of stuff. So
Cheryl, will you also share your contact information so people can get a hold of you?
Oh, absolutely. My email is cherylp@thearcww.org, or you can reach us here at the phone by phone 734-729-9100. I'm actually at extension 202.
So I'll just give a advertisement for the ARC of Western Wayne County. I have worked with folks for a long, long time, and they are the intelligent advocacy for our county. They have done wonderful things for family. And so if you're ever wondering and you need just a little bit of help with a special education question, your first stop ought to be Cheryl Polite and her friends that work with her, because they are absolutely a wealth of information, and they'll tell you exactly what it is, and they'll explain it to you, and they'll even show you where it comes from and things like that. And if it's a complex thing, they're going to put you in touch with people like Patty to make sure that you're getting the things that you need to help advocate intelligently for your child.
Thank you, Charlie.
yeah,
I'll make sure I pass that on to the team.
Yeah, please do.
This is fun.
Please do. So thank you very much, everyone, for joining us. I saw a couple teachers on, and I really appreciate them coming in to learn about these opportunities. I will just ask them if they found anything in particular that might be helpful to a parent to please share that with them, and how to get in touch with this recording. One last thanks for Cheryl for setting this up, and Patty for giving us all the wonderful information. Have a wonderful evening, everyone. And